You're not claiming, though, that you're excused from implementing an unlawful system because you didn't know the law.
Okay.
It's not an excuse that washes with most people. You could appreciate that.
So what's the question?
Are you claiming ignorance of the law when
No.
you set up the unlawful system?
Didn't that tell you that there was a fundamental problem with the program?
Told me there's a fundamental problem with the Australian education system where people can't understand averaging.
That's what's being said.
That is what
there,
is
isn't it?
said there. Yes.
Okay, it's untrue.
This is a summary of week 3 of the Royal Commission into Robodebt. If you haven't watched the previous videos, they've got all the background. I'll link to week 1 in the description, and things will make a lot more sense if you start there. The Royal Commission publishes these hearings on their website, and week 3 has 34 hours of footage. So that you can stay up to date and hear the evidence for yourself, I've cut the footage down to something digestible. This week continued to look at who was involved with developing Robodebt, but it also looked at the failed Commonwealth Ombudsman investigation in 2017. That investigation failed to pick up that the scheme was unlawful, and this had a massive flow-on effect because the government referred to that report anytime someone criticised the scheme. Turns out there was a lot of influencing going on behind the scenes to make sure that the report wasn't too negative. But let's get into it. This is week 3. First up was Jason McNamara, a senior executive with the Department of Human Services, or DHS. To be honest, I found something a bit unsettling about how he gave evidence.
You joined the Department of Human Services, what is now Services Australia, on the 26th of April 2016?
That's correct.
Around 2017, when Robodebt started getting a lot of attention, he was asked to help out and reported in to Melissa Golightly. You might remember her from week 2, and it seems she was instrumental in getting Robodebt off the ground.
And so when you came into Melissa's section in early 2017, what role did you perform?
So day to day, I was probably I was dealing with media requests. So there was often requests to our media unit about an aspect of the income compliance program, and I'd be helping in terms of shaping the responses that would go back to whichever media outlet.
Is it the case that at some stage in this period in early 2017, you became involved in assisting with the department's response to a Senate inquiry into the Robodebt scheme?
Yes, I did.
Am I right that you saw your role as in responding to these various public inquiries and the media to push out the department's narrative in relation to this negative reporting? Would that be right?
Yeah, try and counter some of the misreporting and misinformation that was happening at the time. I definitely think I arrived at 2017, it was a crisis. It was in the middle of a crisis.
Right. And then, of course, in early 2017, the Ombudsman commenced an investigation into the Robodebt scheme.
Yeah, I don't know when, but yeah, around about that time, yep.
All right. And you were involved in responding to inquiries by the Ombudsman?
Yes.
And providing information to the Ombudsman?
Yep.
And did you understand that your role that we just discussed before about pushing out the department's narrative extended to doing that with respect to the Ombudsman's inquiry?
Yeah. No, we would have made sure that we had alignment with our messaging externally, including to the Ombudsman. Yep.
Would this be right? The Ombudsman inquiry represented a risk to the department in that it might result in findings and recommendations that were adverse to the interests of the department?
Yeah, it could be, but I think I took the view that it was more an opportunity than a risk. But yes, there was a risk, obviously, if they came up with negative comments or pushed us to do things that were beyond our capability, then that would be a negative.
His job was to push the government's narrative to the media, Senate inquiries, and the Commonwealth Ombudsman. I want to spend a bit of time on his evidence on how the department dealt with the Ombudsman. Remember, the Commonwealth Ombudsman is supposed to be a federal oversight body that investigates government departments. On their website, they say, "We are independent and we don't take sides." Let's see how true that really is.
You can see this is an email from Louise McLeod to Michael Robinson on the 30th of January 2017. You see that?
Yep, I do.
All right. Now, who's Louise McLeod, to your knowledge?
Oh, Louise was one of the senior people in the Ombudsman's office.
Right. So we can see signature block at the bottom of that
Yep.
image, Senior Assistant Ombudsman.
Yep.
It says, "Hi Michael and Jason, as flagged, please find attached the proposed outline for the own motion investigation report into the OCI."
Yep.
Email from Mr Robinson to Karen Harfield, dated the 30th of January 2017. Says, "Karen, having read the report outline, I think the department has been given a great opportunity to effectively co-write the report with the Ombudsman's office. Given the time pressure the OO is under, any suggested wording you provide in response to their dot points will enable them to do a quick copy and paste in many instances." See that?
Yep.
And this is an opportunity for the department to effectively cut and paste tranches of its own wording into the Ombudsman's report. Do you agree with that?
I think we can definitely put material to them. Yeah, it's an opportunity to put material to them, yeah.
Well, it's not just put material to them, it's cut and paste tranches.
Yeah, but the Ombudsman's an independent statutory office holder. If he wants to reject our words,
Well,
it's up to him.
well, the time...
But there's nothing wrong with suggesting wording. This is fairly normal practice with both Ombudsman and ANAO reports, is you suggest very detailed, how about you change your recommendations from this to that? Fairly normal practice. In my experience, it's fairly normal practice for both the Ombudsman and the Auditor General to reject those suggestions, but APS agencies do that all the time.
cut and paste words into the
Yeah.
independent body's report.
But in the end of the day, the Ombudsman's signing off the report. He's not happy with it. He's not going to sign off on it. He's going to say, sorry, no.
So apparently it's normal for government departments to recommend wording be inserted into independent oversight reports. Let's see how this played out with the Robodebt investigation specifically.
Now, you see that's an email from Mr Hutson
Yep.
to Miss Campbell.
Yep.
You're one of the people copied to the email.
That's right.
It says, "Kathryn, for your information, this afternoon I met with Annette, which must be Miss Mussolino,
That's right.
Jason, that must be you,
Yes, that's right.
and others. Met with Richard Glenn, AG Ombudsman,
Yep.
that was the acting Ombudsman,
That's right.
and his staff working on the OCI report. The meeting was productive, agreeing a finalisation process and key changes to recommendations and findings."
Yep.
See that?
Yep.
And it says, "It was agreed that the Ombudsman's office would develop a new draft report based on today and additional material discussions." See that?
Yep.
Now, do you recall a meeting at about this time involving yourself, Miss Mussolino, and the acting Ombudsman?
Yeah, and I remember going to this meeting.
What was discussed was a then draft of the Ombudsman's report.
Yes. Yep.
And am I right that you and perhaps Miss Mussolino raised some issues that the department had with the draft?
Yeah, no, that'd be fair comment. I think that's the nature of the discussion.
And was the effect or the outcome from that discussion that the Ombudsman's office would develop a new draft of the report?
Yes.
And they agreed that a number of recommendations would need redrafting,
Yes.
and that alternate draft recommendations would be provided by DHS to the Ombudsman for the Ombudsman's consideration.
Yes.
And the Andrew Aston who is to be kept informed of progress was?
Minister Tudge's Chief of Staff.
Thank you.
Did you have an understanding that the Minister's office needed to be kept informed about the progress of this matter?
The Minister's office needed to be kept informed about the progress of anything to do with this program after it went off the rails at the start of January. It was hypercare. There was anything that went with the program, you had to talk to the Minister's office.
There was a meeting between DHS and the Ombudsman, and the Ombudsman agreed that they would rewrite their draft report and change their recommendations. And there were a ton of changes. Here's just one example.
And you can see here, it's an email from Mr. Robinson to Ms. McLeod,
Yep.
dated the 20th of March 2017.
Yep.
So that is the following Monday.
Yep.
And you can see the attachments, track changes to draft own motion report. The text of the email from Mr. Robinson says, Louise, and Louise is Louise McLeod, who we've established before was from the Ombudsman's office.
That's right. Yep.
Attached is the marked up version following today's discussion and some feedback from other areas that I've incorporated. So those are words that have been added by someone from DHS
Yep.
to this report drafted by the Ombudsman.
Yep.
And these words, am I right, are consistent with the department's messaging at the time about the program.
Yeah, they would be. Yeah, they are.
And the reason why they would have been added to this report is to ensure that this aspect of the department's messaging is reflected in the Ombudsman's report, correct?
Yes, and the facts are these are a fair few facts about how we think about the program. So yes,
Well, it's how DHS thought about the program.
yes, that's right.
And what you were asking was the Ombudsman to adopt those words.
Or adopt words or adopt those thoughts. Yeah.
And it was important that an independent statutory investigator adopts words such as this to confirm the department's messaging.
Oh, it's useful if they do. Yes, definitely.
Because that would add weight in the public mind to what the department was saying about these matters, correct?
Yeah. Well, in March we're still in the middle of a crisis. We're still in the press every second day. So yes.
Okay. The effect, so the words that were struck through were the words inaccurate debts,
Yeah.
and without the words added, the sentence would have read, this resulted in accurate debts for people with fluctuating or intermittent income.
Yeah. Yeah.
But those words, inaccurate debts, were removed,
Yep.
and with the additional words, the sentence read, this resulted in people with fluctuating or intermittent income having their income evenly apportioned, which in some cases was a more favourable outcome for the customer, and in others the debt was overstated.
Yes. Yep.
And that was the point of making this amendment, so that the words were less negative about the program.
Well, yes, that's part of it, but our legal area did not like those terms because I think the Ombudsman's office was using them in a generic sense, and our legal people were going, well, you're saying it's inaccurate in a legal sense, and it's not. And so they used to discuss the matter, is how I'd put it.
So a part of the department didn't like the wording that was in this draft
Yep.
and caused that wording to be changed.
Yes, yeah. They didn't agree with it. You know, not the lawyer here, but they didn't agree with it as a matter of law that it's an inaccurate debt, so they didn't want that in the report.
This is completely the opposite of how I would expect the Ombudsman investigation to work. But there's more. This redrafting process happened multiple times, with drafts constantly being provided to the department for their review and comment.
Email from Louise McLeod, dated the 23rd of March 2017. It says, hi Michael, please find attached a copy of the marked up report following our consideration of the comments provided by DHS to date.
Yep.
Let me know if you'd like to meet again to discuss.
Yep.
And then if we go to the email at the top, call out, email Michael Robertson to yourself and some others. And it says, Jason and Alison, hot off the press and unexpected, a final bite of the cherry.
Yep.
Do you recall receiving this email?
No, I don't.
Is it consistent with your recollection that the department had a number of opportunities to provide comments in respect of the draft report?
Yeah, no, I recall that we did interact on the report a number of times, yep.
There was also evidence dealing with the final Ombudsman report that was then published publicly. At the end of that report, there's a section with responses from the departments. When I first read this report, when researching for my Robodebt series, I assumed that the Ombudsman had done their investigation first and then forwarded the final report to the departments to give them an opportunity to respond to the findings and recommendations. But now we know that wasn't the case at all, and that this response was all part of the show.
Now, do you recognise that document, Mr McNamara?
Yeah, that looks like the Ombudsman's final report, is it?
Yes.
Yep.
You can see that purports to be a letter on Department of Human Services letterhead.
Yep.
And you can see the top right purports to be from the Secretary of the Department,
Yep.
Kathryn Campbell.
Yes.
It says, thank you for the opportunity to comment formally on the proposed report titled Centrelex Automated Debt Raising and Recovery System.
Yep.
So this, of course, is after all of the engagements that the department has had with the Ombudsman prior to that time.
Yep.
It says, the Department of Human Services, the department welcomes your finding that the department's online compliance system was designed appropriately, accurately calculates debts and has undergone a range of enhancements that ensure its long-term sustainability. This will provide reassurance that debts were raised consistent with the previous manual debt investigation process.
Yep.
The department agrees with all of your recommendations.
Yep.
But the clear objective of DHS that you were involved in was, through this process of negotiation prior to this point, that is the point of this letter, was to achieve a Ombudsman report that maximised areas of agreement between DHS and the Ombudsman in relation to the report's content and its recommendations.
Yeah, they were the only people out there who wasn't giving us an extremely difficult, unreasonable time. So it was great to have someone there who was constructive while being critical. So yeah, that was what I was trying to do. I was trying to influence them and cultivate that relationship so that they could be a constructive player in our transformation.
Now, the various earlier drafts of this report that were provided to the department for comment, they've never been published, have they?
No, I don't think so.
They've never been made public.
No, because I think, no, not that I know of.
And the various negotiations that took place between the department and the Ombudsman as to the content of the report and its recommendations, they were never published to the world at large either.
No, it's not unusual to go through a myriad of drafts with any of these type of reports, and you don't publish all the drafts.
There's a few things to unpack. First, the witness seems oddly satisfied with how the Ombudsman report turned out, and his role in influencing them. In reality, the report was a complete failure that didn't consider the key questions that could have stopped the scheme in its tracks early on. Instead, it made recommendations that DHS basically wrote for them, suggesting system changes that were already going to happen. I mean, just imagine if the police, in investigating a crime, held meetings with the suspect to make sure they were happy with the wording of their reports. It just makes no sense. The other thing the questioning is getting at is that the public wasn't aware that the department and the Ombudsman were working so closely. Anyone reading the report would incorrectly have thought that it was truly independent. And the reason I've included so much of this evidence is that this issue is important. The Ombudsman's report was consistently used by government in the years that followed to justify the continuation of Robodebt.
Now, that's an email from Rochelle Miller,
Yep.
the 21st of June 2017.
Yep.
Do you know who Rochelle Miller is?
Oh, Rochelle Miller was Minister Tudge's media advisor
Okay.
at that time.
And The words are, "This is a politically motivated and factually inaccurate report, reflecting the fact that Labor and the Greens don't support auditing of the welfare system." See that?
Yep.
Is that in reference to the Senate, the report of the Senate inquiry into the Robodebt scheme? Don't know.
Don't know.
Then you can see the next paragraph. The Ombudsman found that asking welfare recipients to explain discrepancies identified through data matching is reasonable and appropriate, and that the debts raised by the OCI are accurate. And I suggest that this is consistent with the approach that both the Minister's Office and the Department adopted following the Ombudsman's report throughout the further iterations of the Robodebt scheme when adverse publicity happened in relation to that scheme, that is to refer back to the Ombudsman report.
Yeah, an external reference was very useful relative to our spokesman just saying those exact words. Yep.
And that was consistently what was done.
Yes, no, it was a tactic used to, in a very difficult political environment, to respond.
Okay.
All right, let's pivot slightly to a different part of the evidence. The Commission is not holding back with this witness, and they pull out a cover letter for a job he applied for.
Do you recognise this document, Mr.?
Yeah, this is an application.
What's
Didn't
an
do me much
application
good. It's an application for Treasury Deputy position.
Right. And that's what's reflective of the words. "I would welcome the opportunity to take on a role as Deputy Secretary in the Treasury. Such a role would continue to provide me with the wonderful opportunity that I currently enjoy to make an important difference to the people of Australia through delivering on public policy priorities."
That's right.
Can we call out, please, the third paragraph on this screen?
Yep.
All right. Now you see there it says, "I'm calm in a crisis. This provides leadership to a range of people, but especially my fellow SES leaders.
Yep.
I was called into the centre of Robodebt. I established a division from nothing to put the compliance budget measures worth $5 million back on track. At the same time, I shaped the Ombudsman report."
Mm-hmm.
What were you referring to by these words, "I shaped the Ombudsman report"?
Well, one of the SES criteria is influencing and communicating with influencing. So, that's what you're trying to address in that, is to be able to say that I was able to successfully influence independent decision maker. It's important, like the Ombudsman, the Auditor General, these people don't necessarily take a lot of feedback, so I'm trying to say I was able to successfully influence them.
To shape their report.
Yeah, because normally most of those independent people will reject things, and I think I was able to use my skills to influence that in terms of my intellect and my knowledge to change their minds.
Right. That can be taken down.
Not something I would have thought you'd be proud about. With all this evidence, you have to keep in mind that the bigger problem is actually the fact that the Ombudsman could be so easily influenced. That's what I have a bigger issue with. Another topic the witness gave evidence on was the development of the Robodebt letters. They were notorious for being hard to understand and for failing to explain what would happen if you couldn't provide the required information. Here is evidence about user testing that was done on the latest letters developed by the department.
Recognise that document?
Yeah, no, it's the user feedback. Yep. No,
This is the report of the user testing.
yeah, this is one of the user testing reports. Yep.
Only 2 participants of the 15 were able to correctly explain in their own words the concept of averaging and what would happen if they did not provide their correct information to Centrelink.
Yep.
This is telling you that on the proposed revised initiation letter,
Yeah.
that only 2 of the 15 participants tested understood that they were at risk of their entitlements being calculated using income averaging.
Yeah. Yeah, that's right.
It says 8 participants expressed negative feelings after reading the letter. 2 felt that the letter was threatening.
Yep.
Words such as "I would be anxious, I would feel that I've done something wrong." those sorts of words.
Yeah.
Didn't that tell you that there was a fundamental problem with the program?
Told me there's a fundamental problem with the Australian education system where people can't understand averaging. It's pretty poor that people can't understand adding numbers up and dividing by the weeks actually as an average. That's pretty appalling. But that's where we're at as a society, so there you go. I've still got to communicate with those people. I've still got to explain. This was a very difficult process because we wanted to explain it to people, but essentially it was very difficult to do. It's not a... We sort of had to explain averaging first and then the application of averaging. So I had to do both, not just the application of averaging. And that's pretty difficult for us to do.
So the problem is apparently Australia's education system. It's the people who don't understand averaging that are faulty. I must have been wrong in thinking that the problem was all the highly paid executives like this guy, and all the legal teams and the consultants with their great education, who completely failed to identify that they were administering a system that was both unfair and unlawful. Let's see if, with all his intellect, he understands why Robodebt was fundamentally flawed.
But you well know that under the Social Security law, Social Security recipients is generally calculated according to what their actual fortnightly earnings are, aren't you?
With income, yes.
And to a large extent, recipients of Social Security don't earn their income in equal amounts per fortnight.
Well, they may not. Like, I don't know if I have any data to say one way or the other, actually. So,
but intuitively, you must know that for the types of people that are receiving Social Security payments, many of them will not be earning their income in equal amounts. Surely, Mr. McNamara.
well, not necessarily. If they've got a job, if they've got a job that's a part-time job or a job where the hours are variable, then certainly. But if you've got a normal paying job with normal hours, the pay's going to be pretty standard.
The language he's using in his answers is incredible. If only everyone had what he calls normal jobs, there wouldn't have been any issues. Anyway, the time ran out for this witness, and he couldn't answer any further questions. He'll be back another week to give more evidence. The next witness was a Robodebt victim. Centrelink raised a debt against her, which turns out wasn't real. She tried to explain to them a number of times what the facts were, but they wouldn't listen, and only much later did she get a refund.
Can you tell the Commission your full name, please?
Melanie Jane Cleavey.
And you are currently living in Broome in Western Australia,
That's correct.
and that's where you're giving evidence from today.
That's correct.
How did receiving the debt letters and the inability to get any traction on those phone calls with Centrelink affect you?
Oh, it was very stressful. I actually shut down and ignored it for quite a period because it was too much to deal with. And that's usually my coping mechanism is to just ignore until it escalates and I have to deal with it. But I only started ignoring it after it got to the point where there was nothing else I could do. There was no communicating with Centrelink. They wouldn't listen. They wouldn't do anything about my information I was giving them. They were just adamant that I needed to supply proof. With this, it made me feel like I was a criminal. And it made me feel like what I assume a lot of people on Centrelink feel like most of their life.
The next witness worked on Robodebt at DHS. In 2019, which is the part of his evidence I want to focus on, he worked in the legal division. And this was around the time the first federal court cases were popping up, threatening to expose Robodebt in the courts.
Mr. Storen, would you please tell the Commission your full name?
Craig Andrew Storen.
Commenced in November 2014 as General Manager Aged Care Programs in the Department of Human Services.
Yes.
And then from the 1st of May 2017 to 22 December 2019, you held the role of General Manager, Customer Compliance Division in that department.
Yes.
The key evidence here was around advice DHS received from the Australian Government Solicitor in early 2019. This advice was about the Masterton case. If you remember from week 1, Madeline Masterton was the first person to go to the federal court to test the legality of Robodebt. The government panicked and refunded her debt so that she would no longer have a case to pursue. What the evidence here is showing is that the department knew at this point that the scheme was unlawful, but even then they didn't do anything to stop it.
It's an email from Mr. French to Miss Mussolino, CCing yourself and Mr. Rosa. See that?
Yes.
There's a draft advice on prospects in Masterton is attached. AGS considered that Miss Masterton has good prospects of succeeding in a claim for relief on the basis that the use of apportioned ATO PAYG data will not establish that she owed a debt under Section 1223, subsection 1. See that?
Yes.
Okay. You recognise this document, Mr. Storen?
I recognise the header and so forth, but not the document itself.
Okay, well, I'll take you through it. See, it's dated the 27th of March 2019.
Yes.
It has AGS header on it. See that?
Yep. Yes.
I note particularly A2 at the bottom. The applicant presently has very good prospects of succeeding in the claim on the basis that the second alleged debt contains calculation errors. See that?
Yes.
And if we go over the next page, first bullet point, one of the errors is identified. The top of the page, portioned ATO PAYG data does not establish that the applicant owes a debt under Section 1223, subsection 1. See that?
Yes.
Para 42 says there is no statutory basis in the SSA, which is, of course, a reference to the Social Security Act. Correct?
Yep. Yes.
No statutory basis in the SSA or related legislation for deeming a portioned fortnightly income to be accurate or provide a sufficient basis on which to raise and pursue a debt. See that?
Yes.
Right. And have you seen enough of this document to recognise what it is now?
Yes.
This is the draft advice that was attached to the email I showed you just before. Thank you. This is the draft advice from the AGS about the Masterton case, correct?
Yes.
This is advice received by you on the 27th of March 2019.
CC to me on that day, yes.
Yes. Do you recall reading that advice?
I don't recall the whole specific advice. I do recall various elements of it. Whether it was from that advice or other pieces, I couldn't be certain.
The advice clearly indicates that income averaging to calculate social security entitlements is unlawful, doesn't it?
It's saying there's no statutory basis.
Which means it's unlawful.
In the context of the Masterton facts is my understanding of what the advice was provided for.
Are you saying that you understood this advice was limited to the circumstances of Miss Masterton's case?
My recollection of conversations at the time was that the advice was related to the circumstances of the Masterton case.
So when it said there's no statutory basis for averaging, you thought that was there's no statutory basis in relation to Ms. Masterton, but for everybody else it's fine.
I don't recall reading that specific paragraph, but my general understanding at the time was that the way the legal position on the Masterton case was related to the facts of the Masterton case.
The witness please be shown paragraph 65 on page 15 of the document. See, it says the scope of our advice is confined to the prospects of the applicant succeeding in a claim in the federal court. See that?
Yes.
You see the next words, we are conscious that the conclusion we have reached about the use of apportioned data where a person has inconsistent income like the applicant has broader implications. And then the recommendation is made about seeking further advice.
Yes.
You remember reading this passage?
I don't remember reading this passage, but I do recall that there was a process kicked off, whether it was a process commenced to seek wider advice on the overall legal position of apportionment.
So just to be clear, are you saying that this advice did not lead you to the realisation that use of income averaging to calculate social security entitlements was unlawful?
The advice wasn't sent to me, I was copied it. I was aware of the general thrust of the advice, whether from reading the advice in toto itself or not, I can't tell you. And I was aware that there was then processes in place to seek a firmer Commonwealth position on the legality of apportionment.
The witness received the advice saying that Robodebt was unlawful, but he's acting as if he wasn't really involved. He was just copied in, and that he thought the advice only related to the Masterton case. Except it turns out the Commission had documents that he had prepared for the government, summarising the advice, including the fact that it had wider implications on the overall scheme.
And the next words are the question of providing specific legislative direction to authorise income averaging may need to be considered in the future.
Yes,
Do you see that?
yes.
Do you remember preparing this document?
No,
No memory of it.
no. As I said previously, from the Masterton to Amato to the class action is a blur of legal documents and briefings in my recollection. So I don't recall this specific document.
Counsel assisting then zeroes in on the witness on what he knew at the time.
The advice explicitly acknowledged that it had broader implications, didn't it?
There could be broader implications, yes.
And that the advice explicitly stated that the use of income apportionment, i.e. income averaging, was not a lawful basis to calculate a debt.
Yes.
And did not state that only was the case for Mr. Masterton, did it?
My understanding is the legal advice was provided in the context of the Masterton case, but it brought into question the use of apportionment more broadly. Yes.
Yes. Because it was commenting on the provisions of the social security legislation that didn't just apply in the Masterton case, they apply to social security recipients generally.
More generally, yes.
And so it was clearly not limited in its application to the Masterton case, was it?
By implication, no.
And so your then knowledge, after having been informed of that advice, and as reflected in this document, attached to an email dated 10 April 2019, was that the use of income averaging to calculate social security entitlements was unlawful.
So the advice was in the context of the Masterton case, and my understanding at the time was the Commonwealth needed to consider its position more broadly.
Why would it need to consider its position more broadly?
I can't tell you that. I don't understand. I don't understand why that position was taken. My role at the time was delivering a function in accordance with the government's policy at the time. There were questions being raised, as you pointed out, and the Commonwealth was yet to determine its position on where it wanted to take the delivery of the program.
Commissioner, that's the evidence of this witness.
The department failed to act on clear advice. Instead, they moved to shut down the Masterton case by cancelling her debt, and then successfully argued that the court no longer had a live issue to rule on. This meant that Robodebt kept running for many more months, even though it was plainly obvious that the scheme was unlawful. We now move to a very senior official within DHS at the time of Robodebt, in charge of the legal division. He reported to Secretary Kathryn Campbell.
Thanks. Take a seat again. Thanks very much. Yes.
Thank you, Commissioner. Mr Hutson, would you please tell the Commission your full name?
Jonathan Hutson.
It's the case, isn't it, that you were the Deputy Secretary Enabling Services from sometime in the second half of 2013 to 11 September 2017?
That's correct.
Okay.
This evidence revisits the department's meddling with the Ombudsman investigation in 2017.
You can see that's an email from yourself to Richard Glenn, dated the 3rd of February 2017.
Yes.
Richard Glenn, of course, was the acting Ombudsman, as we've seen from earlier emails.
Yes.
Your email says, "Thank you for sharing the outline with us.
Yes.
As you'll see from our comments on the attached, we have quite a long way to go." See that?
Yes.
We remain committed to working with you to resolve misunderstandings.
Yes.
So at this stage, there was substantial disagreement, wasn't there, between the department and the Ombudsman as to what was set out in the Ombudsman's outline of its proposed report.
I don't agree that to characterise those things as disagreements at this stage. The Ombudsman's views were quite preliminary. The department's views were a bit more settled, and that's why I describe it in my email as misunderstandings rather than disagreements.
Well, I'm highlighting the words "have quite a long way to go."
Yes, there was certainly a significant difference between the position outlined in the outline and our response to that. Yes.
Do you recognise this to be the outline that was referenced in the previous email?
Yes, I believe this was an attachment to that email.
Yes. Some of the wording is in green.
Yes.
And may we take it that the wording in green is wording inserted by the department,
I believe so, yes.
which reflected the department's position,
Yes.
and the other wording that's not in green is what was the original wording from the draft outline?
I believe that's correct, yes.
Okay. And you see the words, "Our goal for tomorrow is to go through the paper."
Yes.
What paper do you understand that to be referring to?
Draft outline
That we've just been
that
looking
we've
at.
just been looking at, yes.
Okay. And it says, "See if we can minimise areas of concern for the Ombudsman." See that?
Yes.
And then the words, "and take out problem areas, particularly the sections on," it says "and," but presumably you mean on, "accuracy and fairness." You see that?
Yes.
Now, do you see all of that?
Yes.
Would that be the reference to the fairness aspect that's
I believe that's correct.
right? And when you said in the email, "take out that part," what were you meaning to say?
In the email when I said take out means, doesn't necessarily mean there be no reference to it within the Ombudsman's report, but we take out the problem, that is the misunderstanding would be resolved.
I suggest you're concerned that there be findings that the process, that is, the Robodebt scheme, was unfair.
That would have been a concern if that had been a finding of the Ombudsman's office, yes.
And your objective was to ensure that wasn't in the report.
Our objective was to ensure that the Ombudsman had access to all the information and evidence that he required in order to form a judgment. Whether or not he formed a judgment as to the fairness of the process was a matter for the Ombudsman. Our objective was to present what we were doing in the best possible light.
And to achieve the objective of having adverse findings about the fairness of the process not included in the report.
I think that the matter of making a decision about fairness of the process was a matter for the Ombudsman.
It was not in the interest of the department or findings to be in the report adversely commenting on the fairness of the process, was it?
No, it would not have been.
And you wanted to pursue the interests of the department as a Deputy Secretary of the department, didn't you?
That was my job.
And therefore, you sought to pursue the objective of having findings in the report about the fairness of the process not included in the report.
I repeat that our objective was to ensure that the report was evidence-based, which is what they asked for. Our objective was very much to have a report that satisfied the needs of the Ombudsman. And yes, you're right, we were seeking to advance the interest of the department.
I'm stating the obvious, but Robodebt was neither fair nor accurate. We're going to move away from the Ombudsman report to other evidence from this witness.
See the bottom email in this chain? Call that out, please, from yourself. Date of the 13th of July 2017.
Yes,
To the Secretary's office.
yes,
And you see the subject, Australian Institute of Administrative Law Conference -OCI sessions.
yes,
It says Kathryn for information, you see that?
yes.
And that would be Kathryn Campbell
That was the Secretary, yes,
of the department.
yes,
Okay. And it says for information, the Australian Institute of Administrative Law is holding a conference in Canberra on 20 and 21 July 2017. The conference will include a number of sessions on issues relating to the department's online compliance intervention. See that?
yes,
In the second bullet point, it says Peter Hanks QC, Barrister Owen Dixon, Chambers West, Melbourne Administrative Law and Welfare Rights, the 40-year story from Green and Daniels to Robodebt Recovery. See that?
yes,
And then towards the bottom it says a number of officers from the Legal Services Division will be attending the conference but will be instructed to refrain from commenting on online compliance issues. Do you see that?
yes.
Do you recall sending this email, Mr Hutson?
I don't recall sending it, no.
Right.
Peter Hanks provided the government with early warning about Robodebt in 2017. I covered his article in my Robodebt series, but safe to say his warning was ignored.
And then if we go up to the next email in the chain, from Miss Mussolino, dated the 20th of July, to the Secretary's office, CCing you,
Yes,
says, Secretary, update on AIL conference. Mr Peter Hanks QC spoke at today's conference. His speech was extremely critical of the OCI program. The key criticisms are summarised below. Do you see that?
yes,
It says none of the criticisms are new. However, noting that organisations such as ACOS and Legal Aid were present, the comments may end up in a press release or in the media. Do you see that?
yes,
The media team is monitoring social media and other outlets to see if this gets picked up. Do you see that?
yes.
And then it gives a summary of the criticisms.
That's correct, yes.
First point is Mr Hanks suggested that someone should look to test the matter in the federal court.
Yes,
The third is critical of Ombudsman's report for not questioning whether the process was consistent with the social security law. See that?
yes,
Fourth point suggests that raising of debts using averaging is not consistent with the terms of the social security law.
yes,
And fifth suggests that the law provides no scope to put the onus on the customer to provide information that they do not owe a debt. Do you see all of that?
yes,
Okay. And you were CC to this email?
yes,
Do you recall reading it?
no,
Okay. Do you know who Mr Hanks is, Mr Hutson?
no, other than what's described here.
You know that he is a very experienced and eminent public law QC.
No,
Do you know that he is the author of a legal textbook on constitutional law that law students are taught at university with?
no,
And he is frequently briefed on behalf of the Commonwealth in public law matters. Did you know that?
no,
And he's appeared in the High Court on a number of occasions. Did you know that?
no,
Okay. See, this is an instance, isn't it, of the department having knowledge of an independent opinion from an eminent barrister knowledgeable in the law, as at the 20th of July 2017, that the Robodebt scheme was unlawful insofar as it used income averaging. Do you accept that?
yes, that's what he says.
Yes. And the concern identified by Ms Mussolino in her email is not that his opinion might be right, it's that there might be some adverse press about it.
That's correct.
Well, Mr. Hutson, you identified to the Secretary yourself that this conference was upcoming,
Yes,
and you noted who was speaking and what they were speaking about.
yes.
So you surely had an interest in Ms. Mussolino's email about what Mr. Hanks said about the scheme.
I understand what the point you're making, but as I said, I have no recollection of this exchange at all.
And so the issue of concern that you identify in this email was the prospect of media interest in the conference.
Yes,
And I suggest that that was your only interest in this conference.
at this stage, yes.
I'm going to play one last snippet from this witness. He's being grilled about the statement he prepared for the Commission.
State in the first two sentences, it is my view now that income averaging is clearly an imperfect substitute for accurate fortnightly income data. Using income averaging to calculate a debt will rarely produce a result that equates with actual fortnightly earnings. You see that?
Yes,
And that's because, isn't it, Social Security recipients often have incomes that vary from fortnight to fortnight.
yes.
It cannot therefore be safely assumed without evidence that the recipient's fortnightly incomes are accurately reflected in a calculation using income averaging.
They cannot be accurately reflected. That's right, and that's right.
And you knew this at the time that the Robodebt scheme was being implemented.
At the time when the Robodebt scheme was being implemented, I understood that using income averaging was authorised by Social Security law.
Well, I'm not asking whether you thought it was authorised, I'm asking whether you realised it was inaccurate.
Well, the question is a little different, I'm afraid, because the point here is that if it was authorised by Social Security law, then under the law it wasn't inaccurate, it was merely different. So if the law provided that a person could have income as they declared it, used to calculate their payments, or indeed, if they chose not to declare it, the law provided that income averaging could be used, then yes, there was a difference, but it wasn't inaccurate, it was merely complying with the law.
Well, I'm asking you the accuracy of the calculation as a matter of maths.
No, a different calculation, not accuracy. If the law authorised the use of income averaging, then it would have been an accurate calculation.
Will you answer my question, please, Mr. Hutson? Would it be an inaccurate or accurate calculation using income averaging to calculate how much a person was earning each fortnight?
It would have been accurate.
You're saying it would be accurate to calculate someone's actual fortnightly earnings.
No, that's not what I said. What I said is that the calculation of the amount of payment the person would have received would have been accurate if it had been properly authorised by Social Security law.
So you're saying that, so if I can just understand your evidence, so you're asserting that mathematical accuracy is determined by what you believe the Social Security law said?
Mathematical accuracy of the payment to which the person was entitled was determined by Social Security law.
I'm not asking you what you believe the
I don't
person...
know that this is productive. I can tell you, Mr. Hutson, that the law can deem non-facts to be facts and the untrue to be true. And
Indeed.
It doesn't follow that because it's legal, it's accurate.
Yes.
So I think all that council is trying to get from you is that, setting aside the lawfulness of it,
Sure.
you wouldn't necessarily come up with an accurate result if you did it this way.
You wouldn't come up with an accurate fortnightly calculation of a person's earnings. No. You would have a different calculation. That's true. Absolutely, Commissioner. I agree with you.
Thank you, Commissioner.
In between the witnesses giving evidence, there was also an interesting appearance by Scott Morrison's lawyers. They were arguing that documents he referred to in his statement needed to be made public. The problem is, those documents are things like cabinet documents that are highly protected. Scott Morrison's lawyers were asking the Commission to decide to release them anyway. Basically, Scott Morrison is wanting to show that when he was Treasurer and Prime Minister, decisions made by Cabinet were a collective decision of a bunch of ministers, so it essentially dilutes his responsibility. But the Commission didn't see much value in this, saying that a Cabinet decision already has the assumption of collective responsibility, which means all the ministers have made the decision together. And plus, they're more interested in his time as Minister for Social Services. Personally, I think Cabinet documents should be public in general, but it is well-established practice that this isn't the case. It's just funny that Scott Morrison, someone who constantly kept things secret under the pretense of Cabinet secrecy, is now trying to do the opposite when it suddenly suits him.
I just don't understand why those documents, or why his level of detail in relation to the existence of those documents gets anybody any further.
Because, Commissioner, his reputation is on the line and he is entitled to answer the notice in a complete fashion, which seems to him to be complete and truthful. That's what he's done.
But
now, of course,
how is his reputation on the line when he expresses something as a general decision of government as opposed to, well, it went through ERC and that happened on this date with, I don't think there's an enormous level of detail, but there is some, or it went through Cabinet and this happened on this date. Why does that make very much difference?
It makes an enormous difference because it's a collective decision of government as a whole following proper processes rather than a decision of an individual minister. And it's no doubt a vital finding of fact which you will need to make to answer your terms of reference.
But that's precisely my point. We can see that these are government decisions. There's no reason to suppose they are anything else. Why do we need to go into the intricacies of Cabinet and ERC when there's a public interest in not doing so, when there is just no evidence or basis to suggest that he took any particular role in relation to Cabinet decisions? And I'm just setting to one side his position as Minister for Social Security because there are particular documents produced there that he is in a completely different frame of reference for. But in his capacities as Treasurer and Prime Minister, I don't think there's any basis for a suggestion that these were not collective decisions of Cabinet. And so I'm struggling to see why his reputation's at risk on those.
What I'm saying, with all respect, is that in an inquiry at this stage, when we put forward the best evidence for something, I don't understand why you don't want it. But if you don't, thank you, that's helpful. But that's what I'm
Dr.
trying to
Rennick, you know
understand.
that's really not the situation. The situation is that I have to determine public interest immunity, a public interest immunity objection, and I have to consider the public interest in preservation of confidentiality of Cabinet material and Cabinet Committee material, and I have to consider the public interest in Mr. Morrison being able to advance his position, which needs me to be able to understand why particular documents actually matter to him. And then there's the public interest in the Commission's own role of discovering what actually happened. Now, if in fact there doesn't seem a lot to discover in some aspects, then that's a consideration in the public interest immunity argument, and I may need it pointed out to me why that is not the case.
Very well. Thank you for that.
So I would prefer that you didn't say things like, oh, well, if you're not interested in having the best documents, you know that is not the heart of this argument at all.
Sharon, look, I should immediately withdraw any suggestion that the Commission wasn't interested in the best evidence. I withdraw that unreservedly.
Thank you.
I don't want to get too caught up in this. The main thing is that Scott Morrison gave evidence the following week, which I'll cover in the next episode. The next day started with a quick update by the Commission. You may remember from week 1 that the Commonwealth Ombudsman was rejecting the Royal Commission's powers to compel it to provide evidence. From everything we've heard, I can see why they wouldn't want to appear.
Last night there was correspondence between the solicitors assisting the Commission and the solicitors assisting the Commonwealth in respect of the Ombudsman. The update is that The Ombudsman's Office is prepared to voluntarily assist the Commission and provide documents to Ms Louise McLeod, who was involved in early 2017, and it is anticipated that Ms McLeod is willing to give a statement and assist the Commission in hearing Block 3.
Thank you.
That's good news. Back to the witnesses. Kathryn Campbell, the head of DHS, gave evidence in the Week 2 video, but she returned again to answer more questions. This time, the focus was on early 2017 and onwards, when there started to be intense criticism of Robodebt. Her responses this week are ridiculous, and there's a lot of repetition. She keeps going around in circles, saying that she tried really hard to make sure the Robodebt system was easy to engage with. This is irrelevant, given that even if you had the perfect system, if someone didn't respond, then income averaging would be used to calculate a debt, which was inaccurate and unlawful. This video would have been hours longer if I included all her passive-aggressive and arrogant responses, but here are the key snippets.
I'm saying that even when this issue about the criticisms of the OCI policy were front of your mind in January 2017, you did not address your administrative order obligation of the development of policy on service delivery of the OCI program.
I don't accept that.
You didn't turn your mind to the development of policy in respect of the over-calculation of debts and that risk?
I did. I did turn my mind to that by working through the system to ensure that a recipient had the opportunity to engage with the system. And that was my focus.
But irrespective of whether they had the opportunity to engage with the system, many people did not engage with the system, correct?
I know that, yes.
You knew that in 2017.
And we strove...
Yes, you knew that in 2017.
I knew in 2017 that people had not been able to engage with the system.
Or chose not to.
Which is why I worked diligently to work out how we could get people to engage with the system.
But why does it matter whether they can engage or not, where a significant number of recipients did not engage and debts were calculated according to averaging, which might be too high?
Because the legal advice that we were provided by the Department of Social Services at the start of 2017 said averaging could be used as a last resort. And so I didn't want to use averaging as a last resort. I wanted the citizen, the recipient, to be able to engage with the system and clarify what was going on.
Didn't it trouble you that using averaging might lead to the calculation of debts which did not exist in whole or in part, irrespective of legal advice about their validity?
So, did it trouble me?
Yes.
So I was troubled that citizens weren't able to engage with the system.
Why was that more important to you than the concern about the prospect that averaging might create debts which didn't exist?
Because I didn't want to use averaging. That's why.
And why didn't you use it? Then why did you use it?
Because the legal advice said that we had received from DSS that averaging could be used as a last resort. And so we didn't want to do that, which is why we worked hard to ensure that the recipients could engage with the system and work through it. And then we would only use averaging as a last resort.
But if it were really going to be a last resort, DHS would use its powers with employers, for example, to get the information. You can hardly say it was a last resort just because you'd asked the customer and they hadn't responded.
That was how we interpreted it at that time, Commissioner.
That an absence of reply meant that you could then say, oh, well, there's no other option, we will average.
So I think the brief to Minister Tudge in August of 2017 indicated the steps that we had gone through and that there would be two, I think the term was genuine attempts to...
Yeah, I understand all that, but the point is that there are other measures you could have taken even on this last resort approach, such as asking the employers or perhaps going back through the person's social security file to see if there were separation certificates. But it doesn't seem that those kinds of steps were being taken.
It might be worthwhile me seeing if I can find that document in 2016 and 2017, because I think there may have been some reviews of the Social Security file, but no, not the engagement with the employer.
Right, well then it wasn't a last resort, was it? Because you could have done something else to find out the facts.
Those actions could have been taken, yes.
Okay, thank you.
And the fact that those actions were not taken was a significant change in the way debts were calculated.
Yes.
And that's not reflected in the annual report, is it?
I think, no.
After her evidence is dismantled by the Commission, the questioning quickly shifts to the annual report. This is in reference to the 2017 DHS annual report, which turns out was misleading the public about the Robodebt program. The annual report is of course signed by the Secretary. The Commission was most interested in this section, which blatantly said that Robodebt hadn't changed anything when it came to how debts were being raised.
The annual report conveys that there has been no change to how the way income was assessed or the differences were calculated.
I thought I had earlier agreed that this was not the best wording of this document.
Well, it's not a matter of best or better. It in fact conveys a position which is not factually accurate. Correct?
Yes.
So the factual inaccuracies of this statement are at least three in number. The first is the significant change in the transfer of the obligation from Centrelink proving a debt to a recipient proving an entitlement. The next is that the significant change that ATO PAYG data is not merely one piece of the evidentiary puzzle anymore, but it has primacy as a trusted source under an averaging approach. And thirdly, that averaging is no longer a last resort because none of the powers that Centrelink can undertake to gather evidence on its own behalf were being exercised.
Those are the changes I identified. Yes.
And they're three significant changes, aren't they?
Yes.
And this communicates the opposite, doesn't it?
This does not communicate as accurately as I would if I wrote it today.
Well, it's so inaccurate that it communicates something very different. Would you agree?
I agree that this is not an accurate reflection of, and it could have been written better.
This paragraph is misleading.
I have said this paragraph is incorrect, and so misleading is another term for incorrect for me.
All right.
I'm going to skip ahead now to the final segment I want to show for this witness. They're talking about the obligation she had to consider the legality of the Robodebt scheme that her department was administering. As it turns out, this obligation didn't seem to have been fulfilled.
I accept that that was wrong now, but that was the thinking at the time.
Well, wrong in a fairness sense or wrong legally? What are you accepting?
Wrong legally because we were not able to compel people to engage with us. And we were not able to use averaging as a last resort.
Yes, which probably means you couldn't use it as a first resort either.
I think we've been here. We could go.
You couldn't set up a system based on averaging.
So I think we have explored this before, Council. I'm happy to explore it again. But
You're not claiming, though, that you're excused from implementing an unlawful system because you didn't know the law.
okay,
It's not an excuse that washes with most people. You could appreciate that.
so what's the question?
Are you claiming ignorance of the law when
No.
you set up the unlawful system?
So, in 2015, when we briefed Minister Morrison, I was advised, and we put it in the brief, that DSS thought there would be a requirement for legal and policy change. at some point in time in briefing the Cabinet and getting agreement for the proposal, that changed. I don't know when that changed.
Right. What you're saying is, despite your understanding there about the need for legislative change required to implement the measure in respect of the use of PAYG information, it didn't occur to you that without legislative change it might be unlawful?
I didn't turn my mind to it because I wasn't focused on the legislative change.
But you ought to have been, because it was your responsibility to ensure the lawfulness of the delivery of the OCI program.
And I have previously said that I wish I had done it, but at that stage I had relied on DSS.
It's not a matter of wishing or not wishing, it's a matter of obligation. You ought to have been concerned about it because of your obligation.
So the way DSS and DHS worked at that time was that DSS was responsible for the legislative change. It was necessary to delegate to other people some responsibilities in order to run an organisation that large. And so, no, I did not personally seek legal advice to ensure that this program was lawful.
I mean, you can't say who did in your department.
I can't say who did because I'm not able to access any other documents.
The thing is, this isn't about her personally asking for legal advice, or her personally being involved in every step of every process the department has. But it's caring enough about legality to have proper processes in place so that the department which she ran sought legal advice for the proposals they were responsible for. But legality didn't seem top of mind for anyone, even when a media crisis was unfolding.
Response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks. Take a seat. Yes, Mr Gregory.
Yes, thank you. Could you tell the Commission your full name, please?
Andrew William Whitecross.
Relevant to the issues with which this Commission is concerned, you were, your substantive role was that of Branch Manager Rates and Means Testing Policy in the Social Security stream. It's the Department of Social Services for the period from April 2014 to June 2017. That's correct?
That's correct.
I want to give some quick background before we get into this witness's evidence. If you remember the week 1 video, there was a witness called Mark Jones who was working at DSS in 2014. Mark Jones asked for legal advice on the Robodebt proposal. That advice flagged that it would be unlawful. He then passed it on up the chain, and eventually it came to the attention of this current witness, Andrew Whitecross. He summarised it and gave it to Serena Wilson so that it could be given to DHS so they would reconsider their proposal. Not long after, there was a meeting set up in early 2015 between DSS and DHS to discuss the proposal in more detail.
Now, you set out here that you attended a meeting with Ms Halbert, Mr Withnell and Ms Rule of DHS by teleconference. You don't have any record of the notes taken during the meeting, but you do have a recollection of it.
Yes, I do.
And do you have a recollection of it because it was a significant meeting in your mind at this point in time?
Yes.
This was a meeting attended by people from DHS, including someone called Mark Withnell. He was not happy with the criticism of Robodebt. We'll hear from Mark Withnell later in the video, and his evidence is very interesting.
I felt very strongly about this issue, and I wanted to convey the strength of my feelings about the quality of the proposal and
Or the lack thereof?
well, indeed, yes.
In paragraph E, you refer to Mr Withnell appeared to find the feedback frustrating. What do you recall of his response?
Mr Withnell was indicating that he felt that there was an amount of unrecovered debt out there that had accumulated over a number of years because DHS had not been able to apply as many resources to it as was needed to recover it, that they did. So he wanted to, so that he felt that, this was a way of recovering that debt. He seemed to be particularly unhappy that I was suggesting that he wouldn't be able to realise the level of savings that he'd estimated. And I formed the impression that there was quite an attachment at more senior levels to that level of savings.
Subparagraph F says this: following the meeting, I was not expecting to see the PAYG data proposal again. Is that because you had expressed yourself in what might be described as direct or blunt terms?
Yes. I think for a number of reasons. Because of the strength of the advice that we were conveying, or the strength of attachment to the advice that we were conveying, right, and the bluntness of it, to use your language.
Yes.
But also, I think because of the strength of the reasoning that we were providing. So it just didn't seem to me that the proposal was properly thought through and developed to a point that it could actually go forward.
So the witness told DHS that their Robodebt proposal was rubbish. He didn't expect to see the proposal again.
So, contrary to your expectation that you wouldn't see the proposal again, it turned back up in an email from Ms Golightly at Deputy Secretary level to Ms Halbert at Acting Deputy Secretary level, seeking urgent comments.
That's right.
Very next day.
That's right.
DHS again sent DSS their proposal, asking for urgent comments, but they hadn't addressed the concerns. This witness was out of the office for a few hours, and because an urgent response was needed, someone in his team, Murray Kimber, responded on his behalf. We'll hear from Murray Kimber next, but basically he repeated that the proposal was not supported by law. This response got a strong reaction.
We can see his comment in respect of this proposal, where he puts in direct terms that the proposal would fundamentally change the assessment of income within the social security system and is not supported by current policy or legislation. When you returned to the office after a couple of hours and had the opportunity to review Mr Kimber's email, you then were the author of an email to Ms Halbert at 2:55 p.m.
Yes, I was.
Now, before we come to that email, there was an intervening event.
That's right.
Can you describe to the Commission that intervening event?
So while I was returning to the office, I was driving back from my appointment. I received a call from Ms Halbert. She indicated that she'd had a conversation with Ms Golightly, I don't know when, and that Ms Golightly had expressed to her concerns about the strength of DSS's comments in relation to the PAYG data clean-up proposal. And she wanted me to tone down the comments that Murray had provided in his response.
When you receive a call from a Deputy Secretary who adopts that position and asks you to do something specifically, did you consider that you had much room to move about it?
Well, I took it as a direction. We had a disagreement in the conversation about that because my view was that it merited a firmer response from the department.
You say that you had a disagreement. The result of it was that she maintained her position?
She maintained her position that I needed to change it. She asked me to change it, yeah.
We will hear from Cath Halbert later in the video. The witness toned the wording down, but still made sure that it was clear that the law did not support the proposal.
Can you tell the Commission your full name, please?
Murray Keith Kimber.
And between 1 October 2014 and 31 December 2014, your title was Branch Manager, SES Band 1 of the Social Security Performance and Analysis Branch in DSS.
Yes.
With so many witnesses, it can get a bit confusing where people fit in. We've heard from many people from DSS, but here is a quick summary. Mark Jones reported to Cameron Brown, who reported to Murray Kimber. He was in Andrew Whitecross's team, who reported to Serena Wilson, a Deputy Secretary, and the Secretary was Finn Pratt. Murray Kimber's evidence was consistent with Andrew Whitecross, so I haven't repeated it in this video. These 4 people were trying to warn the department that the Robodebt scheme was unlawful, and they were ignored. The next section of evidence focuses on this level. For a short period of time in 2015, Serena Wilson was on leave, and Cath Halbert became the acting Deputy Secretary. Let's hear from her.
Thank you. Commissioner, Ms Halbert, can you tell the Commission your full name, please?
Kathryn Elizabeth Halbert.
Now, do you recall having a conversation that is over the telephone with Mr Whitecross while he was out of the office or returning from an appointment on his way back to the office, where you talked to him about the need to soften the language?
I don't recall that.
Do you have any recollection of a disagreement with him?
No, I don't have a recollection of a disagreement with him, but we did frequently have different styles of writing, and putting points across, that sort of thing. I wouldn't say, it was a disagreement, but we would have a different approach often, not above and beyond this measure. It wasn't unusual.
Okay.
Regardless of what had been said about toning down the comments, I should be clear that DSS still ended up telling DHS that Robodebt was not supported by the current legislation. The evidence kept going into the next day, and the focus turned to the 2017 Ombudsman investigation.
And what was asked by the acting senior ombudsman was for a copy by 1 March 2017 of the advice from DSS and any other notes, documents or emails that relate to this advice. And so the proposed response that you drafted for consideration by Ms Wilson was set out in the body of the email.
That's right.
The investigation was primarily on DHS, given they were the ones actually implementing Robodebt, but DSS was also being asked questions. That's because they had contributed to the proposal early on, and that's why Cath Halbert was being asked to draft a response to the Ombudsman on behalf of DSS. Now in 2014, you might remember that DSS had obtained legal advice which clearly said Robodebt was unlawful. This witness could have just told the Ombudsman that they had this critical advice and left it at that, but that's not what happened. Instead, her email said this: by early 2015, DSS gained a better understanding of how the revised process would satisfy the legislative requirements. As such, DSS no longer considered that legislation would be required to implement the measure. In other words, she told the Ombudsman that while there was this 2014 advice that said Robodebt was unlawful, for some reason in 2015 DSS changed their mind to think that it was all actually okay. The Commission spent some time on this to try and figure out how this change occurred and whether this response had misled the Ombudsman.
You say by early 2015 DSS gained a better understanding of how the revised process would satisfy the legislative requirements. In particular, DSS understood that the intended implementation model provided recipients with the opportunity to correct any information presented to them based on ATO data matching, particularly smoothing of income data obtained from the ATO. If we pause there, the legislation that you're considering here doesn't address the question of opportunity, it addresses the question of proof of actual income.
I understand that.
Please let me finish.
Sorry.
The legislation you are considering here addresses the question of proof of a debt by reference to actual income in any given fortnightly period, correct?
That's right.
And that the position of DSS in 2015 was that averaged or apportioned or smoothed income from PAYG data was not sufficient evidence of actual income in a fortnightly period, correct?
That was our original position. And in light of the 2017 legal advice, also the explanation from DHS, we came to understand that the ATO data would not be used to apportion income over fortnights unless there was no other information available, combined with the fact that there was a likely overpayment. So it may have been incorrect assessment on our part at the time, but that was the conclusion we came to once we had that legal advice.
Ms Halbert, that was your original position. What you represent in this paragraph is that it changed in early 2015, not as a result of the 2017 legal advice.
So that's where my understanding is coming from.
Yes,
in 2015, I believe that understanding came from the meeting between DHS and DSS.
But you weren't in the meeting.
No, I wasn't. No, this was the information being provided to me.
Okay, what you're representing here is that in early 2015, once you were told that customers would get the opportunity to correct information, you thought that data matching, smoothing of income data was fine and no legislation would be required. Isn't that what you're representing here?
Look, I don't believe that's what we were trying to say. We believe that, well, the department believed in 2015 that DHS was not going to use the ATO data to do income smoothing, and I can't tell you the details of those discussions, but in 2017, when many more changes had been made, the same argument was put to us.
Look at the words here, please.
Yes, I
Ms.
do
Halbert.
see that.
By early 2015, you got a better understanding. You understood that the model provided recipients with the opportunity to correct information based on ATO data matching, particularly smoothing. As such, DSS no longer considered legislation would be required, and advice regarding specific legislative changes were not sought. That's simply untrue, isn't it? DSS didn't come to that view in 2015 or express it.
It may be badly worded, Commissioner, I don't know, but I don't think particularly smoothing of income data from the ATO is an endorsement of smoothing income data.
What's being said there is that DSS formed a view that legislative change was not required in relation to smoothed ATO data averaging, provided there was an opportunity to correct information. Once you were told that an opportunity would exist, DSS was fine with the concept. That's what's being said.
That is what
there,
is
isn't it?
said there, yes.
Okay, it's untrue. DSS could have said to the Ombudsman, look, we've been had, they were averaging, they gave us to understand they weren't, so it's a surprise to us. Because that was the position, wasn't it?
We had that conversation, I believe.
Ms Halbert, can I put one interpretation of events to you?
Yeah.
That is that DSS in 2015 very firmly said that averaging was not within the legislation. The rate calculator required actual fortnightly income to be the basis of assessment of entitlement. That was firmly conveyed to DHS.
That's correct.
DSS then, perhaps turning a bit of a blind eye, came to believe that averaging would not be used because DHS kept saying we're not changing the basis on which we calculate entitlement or overpayments. Well, to put it perhaps more neutrally, it came as a surprise when you were briefed by Ms Golightly in early 2017 to find out that they'd been averaging.
Correct.
And that was in the context of a media blow-up about people getting these debts.
And the Ombudsman's investigation.
Sorry?
And the Ombudsman's investigation.
And the Ombudsman had started an investigation. This is a context in which government ministers have already gone out in support of this program and asserted that everything's fine, nothing to see here. Is that correct?
From my recollection, ministers were in the media about this.
Yes. And so DSS is then in this position where they now find out there has been averaging all along, and they have two choices. One, they can be open with the Ombudsman and say, this is a surprise to us, we don't regard it as within the legislation. We told them that at the beginning. That's one option. And the other option is to try and come in behind DHS and find some legal advice which would provide some possible excuse for this.
No, we were not looking for an excuse for DHS, and I would have to say I was not involved in the 2015, change of approach, etc. But there was certainly anger. I mean, there was anger at what we were finding out. It was not just a surprise.
Ms Halbert, you've said here that there was surprise and anger within DSS in January 2017 once it was made plain that averaging was being used in the calculation of deaths.
That's right, that's my recollection.
That surprise and anger reflected the fact that clear advice was given by DSS in 2015 by you to Ms Golightly that was not permitted according to law.
That's right.
What you represent in your draft letter to the Ombudsman was that, in fact, DSS came to a view in 2015 that legislative change was not required for the application of income smoothing.
I'm not sure that's what we were trying to say, but I believe that we thought...
I'm not asking you what you believe, I'm
No,
asking
okay.
you what you represent.
Right, I understand what you're saying.
My question is, you represented in your draft letter to the Ombudsman that in 2015, DSS came to the view that after a customer had been afforded an opportunity, legislative change was not required to create a debt by income smoothing. That's what you represent.
That is what that says.
That's what you
I've
represented?
tried to explain the way we came to understand that, but I don't believe we were endorsing income smoothing as a concept.
You represented to the Ombudsman a position which, to your surprise and anger, was not true. Ms Halbert, what in fact happened here is that you are giving evidence that you did not try and manipulate the truth to the Ombudsman, correct?
Yes.
When it is abundantly clear from your written words that you did.
Well, I was not trying to mislead the Ombudsman's office, and if I've written it incorrectly, that's my responsibility, but I was not in any way trying, and I in fact offered to meet with them after this email had been sent to explain our position.
This is a big deal because if DSS had told the Ombudsman that they had concerns about the legality of Robodebt, then maybe the Ombudsman would have been forced to do a proper investigation. Later evidence showed that one of this witness's staff had drafted the wording, so it's possible she was misled at the time. But the point is that it was yet another missed opportunity to flag the illegality of Robodebt, possibly because people didn't want to rock the boat.
Thank you.
Thank you, Commissioner. Commissioner, I call Mark Withnell.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr Withnell, would you please tell the Commission your full name?
Yes, Mark Dennis Withnell.
Previously, is this right, between December 2008 and August 2017, you were General Manager of Business Integrity at the Department of Human Services, which has later become known as Services Australia?
Correct.
And would this be right? In that role, you reported to Melissa Golightly?
For some of that time, yes.
This is the last witness of the week, and as we'll see in a minute, he seems to be playing games with the Commission, and they're going to call him out on it. But before we get into that, I want to give you some context of where this witness fits in at DHS. We heard in week 2 from Jason Ryman, who reported into Scott Britton. This witness was more senior and reported into Melissa Golightly, the Deputy Secretary under the Secretary, Kathryn Campbell.
I just ask you a question about your first statement. You see, under that heading it says, I do not have any recollection of the drafting process for this particular executive minute.
Yes.
And is that your evidence? You do not have any recollection of the drafting process for this particular executive minute?
That was my recollection at that time.
Is it still your recollection?
I've been provided with access to some emails from that time. And there was some, not really a draft of the brief, but a collection of information that went on to form part of the brief. Yes.
Would you now accept that you were intimately involved in the drafting process for that executive minute?
I was certainly involved, yes.
Had a substantial involvement?
I guess it depends what you mean by substantial, but yes, I had input to it.
Okay.
Not a good start. But it gets worse. He spends a lot of time pretending that the proposal that he worked on didn't include using income averaging to calculate debts, which was the unlawful part of Robodebt. So none of that apparently had anything to do with him.
So I'm sorry, I'm not sure what your point is, Council.
My point is that this proposal explicitly involved income smoothing to calculate social security entitlements after attempts to engage with a customer.
I'm still not clear where it says that, sorry. I'm not sure where it says it will be used after attempts.
But you were involved, I suggest, intimately in the development of this proposal, and you weren't you?
I was involved in all of these proposals, yes.
And you well knew what was to happen if the customer does not go online and update their information.
Well, no, that's not correct. As I said earlier, these were very much in the formative stage. And so not all of the details had been fine-tuned. At this early point, we were providing an early draft to DSS so they could provide advice to us as to what may or may not be valuable.
Can I just get your position, Mr. Withnell? Is it that after an early notion that averaging would be involved in this new scheme, which ultimately became Robodebt, that was abandoned? There was nothing about it in what went to Mr. Morrison or Mr. Payne or Miss Payne. It wasn't contemplated at that stage. It wasn't contemplated with the new policy proposal. Is that it?
That's, to the best of my recollection, that's how it evolved. Mm-hmm.
So again, he's denying that income averaging to create debts was part of the proposal that he worked on. He's suggesting that that was only added in later. The problem is that the Commission has documents that show the complete opposite to be true. This is an email he received which clarified the understanding at the time. Point 3, which you'll hear about a lot, was very clear. It said if the recipient does not respond, the income would be smoothed over the period of employment. This would involve equal attribution of the income to each fortnight. In other words, income averaging would be used to create a debt.
I'm going to ask you some questions about this email, Mr. Withnell.
Sure. I'm not sure if I've seen it, but it doesn't look familiar, but I'm happy to proceed.
Okay, thank you. Do you agree that it purports to be an email from Scott Britton to yourself?
Yes.
And that it purports to be dated the 21st of January 2015?
Yes.
What I suggest to you is that in these 3 bullet points, Mr. Britton is purporting to describe the proposal that was the subject of the comments from DSS in that previous document. Do you agree with me on that?
Sorry, he's purporting to do what? Sorry?
To describe the proposal that was the subject of the DSS comments in the previous, the attachment to the earlier email that day. Do you agree with me on that?
I'll need to reread them.
The witness then spends a lot of time stalling before being directed specifically to point 3.
So are you saying that this 3rd bullet point is inconsistent with what you understood the proposal to be at this time?
at this time. All I can go on is what's in the PAYG cleanup potential MPP, and they're kind of written quite differently. I'm just trying to see where the difference is. Having not seen this, I don't think, before for several years. I think what he's saying is that in the non-response, a proposal is that the income will be smoothed, which may be consistent with the view at that time.
A lot of his evidence is like this, just stalling, being vague and deflective. The questioning later turns to a meeting DHS had with DSS in 2015. You might remember from earlier, Andrew Whitecross gave evidence that at this meeting, the witness became frustrated at the critical feedback being given about the Robodebt proposal.
Causing this to be provided to you, Mr. Withnell, to ease your understanding.
Sure.
So this is a statement of someone called Andrew Whitecross, provided to the Commission.
Okay.
Do you remember someone called Andrew Whitecross?
The name doesn't ring a bell. That's not, I can't, obviously can't rule out whether I know him or not, but the name doesn't ring a bell for me. Can you give me context of where he's from? Or
Would it assist you if I told you that he was, in this period that we're discussing, in early 2015, an employee of the Department of Social Services?
Okay. Yes.
Do you have any recollection at all of that meeting with Mr. Whitecross and the other person referred to, other persons referred to, Miss Halbert and Miss Rule?
No. As I say, there were many meetings on different elements of the proposals at that time. I don't recall this one specifically.
Well, I suggest to you that a teleconference did occur involving the persons mentioned in this paragraph on this date, the 22nd of January 2015.
Yep.
You can agree with me or not?
Well, I've no reason to doubt that. If he has suggested it occurred, it may well have.
I'm just going to specifically put it to you that at this meeting, you expressed frustration in response to the advice provided by Mr. Whitecross.
Well, Councillor, I don't know if I expressed frustration or not, because I don't recall the meeting. It would be unusual for me, to be honest, but at that point in time, I was going from meeting to meeting, from proposal to proposal, trying to resolve issues, while under considerable pressure from the Deputy Secretary. And so whether the frustration, if I showed it, was related to his advice or just general frustration about how all of the processes were going or the amount of work that had been involved and the amount of trying to reconcile different views, I don't know. As I say, I don't recall the meeting, so I don't know whether I was frustrated, what I was frustrated about if I was. I'm not sure how I can answer that.
Well, what I suggest is that you were frustrated that DSS was maintaining the position that it would not support a proposal using income smoothing.
as I say, I don't think I can change my answer. I just don't recall the meeting. So if Mr. Whitecross had formed a view that I was frustrated or appeared to find it frustrating, I don't know whether I was, if it was in relation to that, or whether it was just a general level of frustration at that point in time with the whole broad process, not just this particular one. I simply don't know.
The evidence was taking so long with this witness that the hearing was adjourned for the week. He will need to return to answer more questions later. But that's my key takeaways from week 3. In the next episode, we'll finally hear from politicians, including Scott Morrison, as well as other senior public servants. I'm really looking forward to that one. This stuff takes a lot of effort, and if you want to support the channel grow, then please check out my Patreon page, link is in the description.